Hello, welcome to AP Sources Simplified. Today we're looking at the famous 1925 Scopes monkey trial. Before getting into the details of the trial, let's take a look at the context. The progressive era, lasting from roughly 1900 to 1920, had seen great reforms sweep across the country as progressives tackled a myriad of societal issues. It culminated with the 19th Amendment, the women's right to vote, in 1920. However, the rest of the 1920s would see a resurgence of conservatism. Some see the 1920s as an era of liberalism with flappers, speakeasies, and jazz. And that was true in the big cities. But for most of America, the 20s saw conservative forces reestablished. First, conservative governments were voted in on the state and national levels, which kicked out many of the progressives. And conservatives brought back a friendlier government to big business and also social conservatism. The Ku Klux Klan had a resurgence across the entire nation, with even northern states having large chapters of Klan members, of which there were members of Congress involved with. This set up a culture war between modernists and fundamentalists that engulfed everything from debates over prohibition, jazz music, immigration, consumerism, and our focus in this video, evolution. The topic of evolution and natural selection goes back to the mid to late 1800s with Charles Darwin's writings. It had been applied to society in something called social Darwinism, in which the elites tried to employ as justification for their wealth and status, which they argued meant that they were more fit than others. Biologists and others attempted to track humans to their origins, with many concluding that humans must have evolved from monkeys or apes. This flew right into the face of those who were more religious and believed the literal interpretation of the Bible, including the story of Adam and Eve in the book of Genesis. In more religious parts of the country, like Tennessee, laws were passed that forbade the teaching of evolution in public schools. The specific act Tennessee passed was called the Butler Act. The nonprofit group, the American Civil Liberties Union, also known as the ACLU, wanted to challenge the law. This is where the namesake of the trial steps in, John T. Scopes, a young football coach from Rhea County High School in Dayton, Tennessee. He substitute taught from time to time, and he agreed to be the ACLU's test subject. Fun fact, the school district was in on this scheme as they thought it would bring notoriety to the city, which it did. John T. Scopes was only looking at a $100 fine, but the fine was not the point of the case. The point was to challenge the Butler Act, which would set up an arena for the modernists and fundamentalists to square off. High-profile lawyers and individuals came on board the legal teams for both the prosecution and the defense. Leading the defense team was famous lawyer Clarence Darrow, who had already built up an incredible resume as a lawyer. The prosecution side features several prominent individuals, but none more so than William Jennings Bryan, former populist and Democratic presidential candidate. He was a central figure of the fundamentalist side. When the trial began, the defense team of Scopes knew they had their work cut out for them, as the deck seemed stacked against them, with an obviously biased judge who quoted Bible verses during the trial. Darrow and his team had a masterful defense of Scopes from a variety of points. One of those was, how could a teacher be reprimanded for simply teaching what was in the textbook, of which the science textbook of Rhea High School had a full chapter on evolution. There were also other key concerns about academic integrity and freedom. One of the most prominent points in the trial came when defense lawyer Darrow asked William Jennings Bryan to take the stand. Having a day to prepare for the event, Darrow was coached by scientists and others who argued in favor of evolution. When Bryan took the stand, Darrow was able to run rhetorical circles around him, questioning many facets of the Bible as literal truth, like the story of Jonah and the whale and Noah's Ark. When asked about the process of determining when the flood occurred, a frustrated Bryan said, quote, "I do not think about things I don't think about," end quote. Of which Darrow replied, quote, "Do you think about things you do think about?" End quote. And Bryan replied, quote, "Well, sometimes," end quote. And the courtroom broke out in a derisive laughter. An exasperated Bryan said that Darrow was slurring at the Bible. Darrow said that Bryan had, quote, "fool ideas that no intelligent Christian on earth believes," end quote. At that, Judge Ralston halted the trial and adjourned the court. The next day, he ruled that Bryan's testimony should be stricken from evidence. While it seemed Darrow got the best of Bryan, some of Bryan's claims would be very influential going forward. One was evolution is scientifically problematic. Another is that evolution undermines morality, society, and religion. And finally, that this position on teaching evolution is supported by considerations like fairness and objectivity. These ideas have been called the pillars of creationism. The arguments from Bryan, Darrow, and the entire trial were printed in newspapers and broadcast on radio across the country. Both sides claimed that they had won the debate, and the outcome of the trial became secondary, of which the courts would uphold the Butler Act, while dismissing the fine against Scopes. The act would be law until it was overturned in 1967. Moving on to who would agree and disagree with the ruling. With the ruling going against Scopes and the teaching of evolution, those that would agree with it would be fundamentalists and many observing Protestants and Catholics, along with conservatives in general. Those that would disagree with the ruling would include modernists, believers of human evolution, some progressives, and those more science-oriented. Later in the 20th century, there will be several cases which will dive into the teaching of evolution versus creationism debate, with evolution generally coming out on top. The first of these is Epperson versus Arkansas, which says states cannot prohibit the teaching of evolution in public school. Next is Edwards versus Aguilar, which states that teaching creation science violates the First Amendment. And finally, Kitzmiller versus Dover, which ruled intelligent design, which is a version of creationism, is religion and not science. Okay, that does it for the Scopes monkey trial. If you liked the video, please click that like button, subscribe to the channel, and share with your friends.